The pen was already in my hand when my father said it. His voice cut through the mahogany-paneled office with practiced disappointment. "You failed to impress me, Florence. This trust was meant for excellence, not mediocrity." I watched him slide the amendment across the polished table. His signature was already there, bold and confident in black ink. My name had been struck through with a single clean line, like crossing an item off a grocery list. Beneath it, my brother's name remained untouched, circled for emphasis. The attorney, Mr. Wesley Campbell, cleared his throat but said nothing. He'd worked with my father for 20 years and knew better than to interrupt. My stepmother, Vivian, sat in the corner pretending to read something on her phone, but I could see the small smile playing at her lips. "Sign here," my father said, tapping the page with his index finger. "Acknowledge receipt of the amendment and your removal as primary beneficiary." My hand didn't shake. I picked up the pen and held it over the signature line, looking at the document that was supposed to humiliate me. The room waited for tears, for protests, for the scene my father clearly expected. Instead, I smiled. "Of course," I said, and signed my name in smooth, steady letters. My father nodded once, satisfied. He'd proven something important about me, or so he thought, for failing to impress. The words echoed in my head as I finished signing. That was the official reason for my disinheritance, written right there in the legal amendment. Not a specific failure, not a documented mistake, just a vague declaration of my inadequacy. My father leaned back in his leather chair, hands folded across his stomach. He was 68 years old, still handsome in that severe way wealth preserves, with silver hair and the kind of confidence that came from never being told no. He'd built Harrington Industries from a small manufacturing company into a multinational corporation worth $800 million. The family trust held another $200 million in investments and property. Until 5 minutes ago, I'd been set to inherit 40% of that trust. My brother, Marcus, would get 40%. The remaining 20% was designated for charitable foundations and distant relatives. It was a structure our grandfather had established 30 years ago, modified slightly when my mother died and my father remarried. Now, according to the amendment I'd just signed, Marcus would receive 75%. Vivian's children from her first marriage, whom my father had barely tolerated until recently, would split 15%. The charities got the remaining 10%. My share, 0. "I trust this clarifies my expectations," my father said, standing. "Excellence is rewarded in this family. Mediocrity is not." I kept smiling. Not a big smile, just a small, pleasant curve of my lips that I knew would confuse him. My father liked reactions he could predict and control. Tears meant he'd won. Anger meant he could lecture me about emotional control. Silence meant submission. But a smile? That was unexpected. "Is something amusing?" he asked, his eyes narrowing slightly. "Not at all," I replied, setting down the pen. "I appreciate the clarity." Vivian looked up from her phone, her expression puzzled. Mr. Campbell shuffled papers unnecessarily, clearly uncomfortable. My father studied me for a moment longer, then dismissed it with a wave of his hand. "Wesley will file this with the trust administrator by end of week," he said. "You'll receive official notification from the family office within 10 days. "I understand." "Good." He collected his copy of the amendment and placed it in his briefcase with the same care he used for important contracts. "You're free to go." Free to go. As if I were being released from detention rather than disinherited from a fortune. I stood slowly, gathering my own copy of the paperwork. The document was 12 pages long, filled with legal language I'd helped draft 3 years ago when the trust underwent its last major revision. That was when I'd been valuable, when my law degree and attention to detail had been impressive enough to involve me in family business. The attorney wouldn't meet my eyes as I walked toward the door. Wesley Campbell had known me since I was 16, had attended my law school graduation, had once told my father I was the sharpest mind in the family. Now he sat silent, a witness to my humiliation, probably already calculating his fee for processing the amendment. "Florence," my father called as I reached the door. I turned, still wearing that small smile. "I expect you to conduct yourself with dignity regarding this matter. No dramatic displays. No running to your brother with complaints." "Of course not," I said. "Good. Family matters stay within the family." I nodded and left, closing the door quietly behind me. The hallway outside my father's study was lined with portraits, 4 generations of Harringtons staring down with varying degrees of stern approval. My grandfather's portrait hung at the end, the man who'd created the trust that was supposed to secure his descendants' futures. He'd included specific clauses, contingencies, and controls. He'd been paranoid about wealth corrupting his family, so he'd built in protections. Rules about education, employment, conduct, mechanisms for removing beneficiaries who violated the trust's principles. My father had always treated those clauses as formalities, old-fashioned restrictions from a different era. He'd skimmed them during reviews, signed off on amendments without reading the fine print, trusted his attorneys to handle the technical details. I hadn't skimmed anything. I'd read every word. My name is Florence Harrington, and for the past 7 years, I haven't just been a daughter waiting for inheritance. I've been the person who actually understood how the family trust worked, not the public story my father told at charity galas about preserving family legacy. The real mechanics, the clauses, the contingencies, the power structures hidden in legal language. I'm 32 years old, a corporate attorney specializing in estate law. My father had been proud of that once, back when he thought my legal knowledge would serve his interests. He'd involved me in trust reviews, asked me to explain complex amendments, used my expertise while treating it as a hobby rather than a profession. 3 years ago, during the last major trust revision, I'd spent 6 months working with Wesley Campbell and 2 other attorneys to modernize the structure. We'd updated outdated language, clarified beneficiary definitions, and added new administrative protocols. My father had signed everything I put in front of him, trusting that I was protecting family interests. I had been, just not in the way he assumed. One of the amendments I drafted included a clause about discretionary redistribution authority. It allowed any beneficiary who was removed from the trust to execute one final administrative action before their removal became permanent. The clause was buried in Section 7, Paragraph 12, Subsection D. It sounded like a formality, a way to ensure smooth transitions. My father had never read Subsection D. I drove home in silence, my copy of the amendment sitting on the passenger seat. My apartment was in the city, a modest 2-bedroom I'd purchased with my own money rather than using family wealth. My father had criticized that choice too, calling it unnecessarily independent when I could have lived in one of the family properties rent-free. But independence had its advantages, like being able to walk into my home office, spread the trust documents across my desk, and work without anyone watching over my shoulder. I pulled out the master trust agreement, the full version, not the summary my father kept in his office. 473 pages of legal language establishing the Harrington Family Trust, its purpose, structure, and governing rules. I'd read this document so many times I could quote sections from memory. Section 7 dealt with beneficiary modifications. It outlined the process for adding or removing people from the trust, the required approvals, the notification procedures. And there, in paragraph 12, subsection D, was the clause I'd written 3 years ago. Any beneficiary removed by amendment shall retain discretionary redistribution authority for a period of 4 to 5 days following receipt of formal notice, during which time said beneficiary may execute one administrative review and restructuring action, subject to compliance with trust principles as established in Section 2. 4 to 5 days. One action, subject to compliance with original principles. My father's amendment had just given me the authority to restructure the entire trust, as long as I followed the rules my grandfather had established. The favoritism had always been obverse. Marcus was the golden child, the son who'd followed my father into the business, who played golf at the right clubs and married the right kind of woman. He was 40 years old, charming in the way people with inherited confidence always are, and completely uninterested in anything that required actual work. My father loved him anyway. Or maybe he loved what Marcus represented, the continuation of the Harrington name through a male heir. I'd spent my childhood trying to earn the same approval. Perfect grades, prestigious law degree, excellent career. Nothing was ever quite enough. My father would praise my accomplishments with one breath and diminish them with the next. Impressive for a woman in a male-dominated field, but not quite the same as running a real business. When I'd made partner at my firm 2 years ago, he'd congratulated me by asking when I planned to use my legal expertise to benefit the family company. When I declined to leave my practice and join Harrington Industries as in-house counsel, his approval had started to cool. The real break had come 6 months ago. I'd questioned a merger my father was pursuing, pointing out potential regulatory issues that could cost the company millions. I'd been right. The deal had fallen apart exactly as I'd predicted, but my father had blamed me for undermining his judgment with unnecessary concerns. Being right was worse than being wrong. It made him look bad. The silence after signing was immediate and absolute. No calls from family members asking if I was okay. No messages from my brother expressing concern. The Harrington family had a peculiar code. If father made a decision, everyone else fell in line. Questioning him meant questioning the entire power structure. I spent the evening reviewing trust documents and making notes. The amendment my father had filed would take 10 days to process through the family office, then another 5 days to receive final approval from the trust administrator. That gave me 15 days before the changes became official. But my 4 to 5 day discretionary authority started the moment I'd signed the document. I had a month and a half to act, and I only needed 2 weeks. The next morning, I called the trust administrator's office. This is Florence Harrington. I'm requesting a standard compliance audit under Section 9, Paragraph 4 of the trust agreement. The administrator, a woman named Patricia Holmes whom I'd met several times during trust reviews, sounded surprised. A compliance audit? Is there a specific concern? Just routine due diligence, I said pleasantly. Given the recent amendment, I'd like to ensure all current beneficiaries remain in compliance with the trust's foundational principles. I see. Papers rustled on her end. That's certainly within your authority. Let me pull up the current beneficiary roster and compliance records. Thank you. I'll send over the formal request by email within the hour. The compliance audit was a tool my grandfather had included specifically to prevent abuse of the trust. Section 9 outlined the standards beneficiaries had to maintain: active employment or education, no criminal convictions, no bankruptcy declarations, adherence to ethical business practices, and participation in at least 2 charitable activities annually. Most of these requirements were loosely enforced. The trust had grown so large that the administrators focused mainly on tax compliance and investment returns. But the standards were still written into the foundation documents, which meant they could be enforced if someone bothered to check. I bothered to check. I spent 3 days compiling documentation, tax returns, employment records, criminal background checks, charitable contribution receipts. I had access to most of this information through the family office database, another advantage of having been involved in trust administration for years. What I found was fascinating. Marcus hadn't held meaningful employment in 5 years. He was listed as consultant to Harrington Industries, but payroll records showed he'd worked an average of 4 hours per week. The trust required beneficiaries to maintain active employment, defined in the appendix as 20 hours minimum weekly engagement in productive work. Marcus was in violation. Vivian's children, the newly added beneficiaries, had no documented charitable activities. The trust required 2 per year. They'd been added to the beneficiary list 6 months ago, which meant they'd had time to comply. They hadn't. But the most interesting discovery involved my father himself. The trust treated him as both administrator and beneficiary, which meant he was subject to the same compliance requirements as everyone else. My grandfather had been specific about that. No one was above the rules, not even his own son. My father was supposed to maintain ethical business practices. That standard was defined in Section 2 as conducting all business activities in compliance with applicable laws and without willful deception. I pulled up the records from the merger I'd questioned 6 months ago. The deal had collapsed because my father's company had misrepresented its environmental compliance status. An internal investigation had found that he'd knowingly provided false documentation to the other company. The deal had died quietly, settled with a confidential payment, but the investigation report was still in the family office files. Willful deception. Documented. Filed. My father had violated the trust's ethical standards, and the evidence was in his own company's records. I compiled everything into a formal compliance report, 37 pages of documentation showing that Marcus, Vivian's children, and my father himself were all in violation of the trust's foundational requirements. Then I submitted it to Patricia Holmes with a simple cover letter, per my discretionary authority under Section 7, Paragraph 12, Subsection D. I am requesting immediate review of beneficiary compliance status and appropriate remedial action. The trust language was beautiful in its precision. My grandfather had been a details person, someone who understood that power came from controlling the fine print. He'd written the trust to be self-correcting. If beneficiaries violated the standards, they could be suspended or removed until they achieved compliance. Discretionary redistribution meant exactly what it sounded like. During a compliance review, funds designated for non-compliant beneficiaries could be redistributed to other purposes aligned with the trust's mission: education, charitable works, family members in good standing. The key phrase was family members in good standing. I'd been removed from the primary beneficiary list, but I was still technically a family member. And unlike everyone else currently on the beneficiary roster, I had no compliance violations. I'd maintained active employment as a corporate attorney. I'd contributed to 3 different charities over the past year. I had no criminal record, no bankruptcies, no ethical violations. I'd done everything my grandfather had intended, not because I was trying to impress anyone, but because those were simply the standards I lived by. The irony was perfect. My father had removed me for failing to impress him while simultaneously violating the very principles his father had established for the family. Patricia Holmes called me 4 days after I submitted the compliance report. Her voice was carefully neutral. "Ms. Harrington, I've reviewed your documentation. The compliance issues you've identified are substantial." I tried to be thorough, I said, keeping my tone professional. "You were very thorough." I heard papers being shuffled. According to the trust agreement, beneficiaries found in violation of foundational standards must be given 30 days to achieve compliance or face suspension of distributions. That's correct. Which means I need to send formal notifications to Marcus Harrington, the Sterling children, Vivian's last name from her previous marriage, and to your father. Mr. Harrington Sr. is also a beneficiary, I confirmed. He's subject to the same standards. Patricia was quiet for a moment. This is unprecedented. In 20 years of administering this trust, we've never had to send a compliance violation notice to the trust's primary administrator. My grandfather didn't write exceptions into the trust language, I said. He believed standards should apply equally. Yes, well. She cleared her throat. The notifications will go out by certified mail tomorrow. Each party will have 30 days to demonstrate compliance. If they cannot, their beneficiary status will be suspended pending remediation. What happens to their allocated distributions during suspension? They are held in escrow for 90 days. If compliance isn't achieved within that time frame, the funds are redistributed according to the discretionary authority clause. She paused. Which would be you, since you initiated the review. I understand. Ms. Harrington, I should mention that this will likely create significant family conflict. Family conflict is not a legal concern, I replied gently. The trust has requirements. Either beneficiaries meet them, or they don't. After Patricia hung up, I sat at my desk feeling the weight of what I'd just set in motion. My father would receive a certified letter informing him that he was in violation of his own father's trust standards. Marcus would learn that his comfortable lifestyle was about to be interrupted by actual requirements. Vivian's children would discover that being added to a trust came with responsibilities. The timing was deliberate. The compliance notifications would arrive before my father's amendment officially processed. He'd be dealing with his own violation while trying to finalize my removal. I didn't have to wait long for the response. My phone rang 2 days later. I let it go to voicemail. My father's voice was tight with controlled anger. "Florence, I don't know what game you're playing, but it ends now. Call me immediately." I deleted the message without responding. 3 more calls came that afternoon. I ignored all of them. Communication through official channels was cleaner, less emotional. Anything my father wanted to say could be said through attorneys or in writing. By the end of the week, Wesley Campbell called. "Florence, your father would like to schedule a meeting to discuss the compliance audit." "There's nothing to discuss," I said. "The audit documented violations. The trust agreement specifies the remediation process." "He believes the audit was retaliatory," Wesley said carefully. "Based on what?" "The audit used the trust's own standards and documentation from the family office database. Everything was factual and properly sourced." The timing was within my discretionary authority period. I had 4 to 5 days to execute an administrative action. I chose to ensure compliance with foundational principles. Wesley sighed. "Florence, this is going to tear the family apart." "The family was already apart," I said. "We're just making it official." The first beneficiary to achieve compliance was Marcus. Within 2 weeks of receiving his notice, he suddenly became a full-time employee of Harrington Industries. Payroll records showed him working 40 hours weekly, complete with detailed time logs and project assignments. I knew my father had arranged it, had created a fictional work schedule to protect Marcus's inheritance. But the trust didn't require legitimate work, just documented employment. Marcus was technically compliant, even if everyone knew it was manufactured. Vivian's children were slower to respond. They scrambled to make charitable donations and attend fundraising events, documenting everything desperately. They achieved compliance 3 days before their deadline. But my father's problem was more complicated. You couldn't fake your way out of documented fraud. The environmental compliance violation was in writing, admitted to in the internal investigation report. The notifications went out exactly as the trust agreement specified. Neutral language, legal precision, no room for emotional appeals. Marcus received confirmation that his employment documentation satisfied the compliance requirement. The Sterling children received similar approval for their charitable activities. My father received notification that he remained in non-compliance with ethical business standards and would be suspended as beneficiary until remediation was achieved. The family office called me on a Monday morning. "Ms. Harrington, we have a situation." "What kind of situation?" I asked, though I already knew. "Your father is suspended as beneficiary, which means he cannot receive distributions from the trust. However, he's also the primary administrator. We need guidance on how to proceed with administrative functions." The trust agreement addresses that in Section 11, I said, when a beneficiary administrator is suspended, the trust transitions to independent trustee governance until compliance is restored. Independent trustees. The administrator sounded nervous. "That means the board we established 3 years ago." "Correct. 3 years ago, during the trust modernization, I'd insisted on creating an independent trustee board. 3 outside professionals who could step in if the primary administrator faced conflicts of interest or compliance issues. My father had agreed, thinking it was just another formality. Those 3 trustees were about to take control of the entire trust. My father left another voicemail. His voice was different this time, not angry, but something close to panic. "Florence, we need to talk about this situation. There's been a misunderstanding. Call me back. Please." The please was new. My father didn't beg. I still didn't call back. Wesley Campbell sent a formal letter requesting a meeting to discuss resolution of compliance issues and restoration of normal trust operations. I responded through my own attorney, politely declining. There was nothing to discuss. The process was already in motion. The independent trustees held their first meeting 2 weeks after my father's suspension. I attended virtually, joining the video conference from my apartment. The 3 trustees were people I'd helped select years ago, a retired judge, a wealth management specialist, and an ethics professor from the university where my grandfather had studied. They knew the trust inside and out because I briefed them thoroughly when they'd been appointed. They understood my grandfather's intentions, the importance of the foundational standards, the mechanisms for maintaining integrity. The judge, Howard Chen, led the meeting. We've reviewed the compliance audit and subsequent actions. Everything appears to have been handled according to trust protocols. Thank you, I said. However, we need to address the suspended distributions. $700 million in trust assets are currently affected by beneficiary suspensions and the pending amendment. The amendment should be set aside, the ethics professor, Dr. Naomi Price, said firmly. It was filed by someone who's now suspended for compliance violations. His administrative authority is questionable. Wesley Campbell, attending on my father's behalf, straightened in his video window. The amendment was filed before the suspension. It should stand. But it hasn't been finalized, the wealth manager, Thomas Rivera, pointed out. And the grounds for the amendment, failing to impress, aren't consistent with the trust's objective standards. The trust specifies removal only for compliance violations or voluntary withdrawal. Howard nodded. Ms. Harrington was removed for subjective reasons by an administrator who was himself violating objective standards. That creates a serious conflict of interest. I watched Wesley's face as he processed the implications. My father's attempt to disinherit me was falling apart, undermined by his own compliance failures. What are you proposing? Wesley asked carefully. We're proposing a complete reinterpretation of beneficiary classifications, Howard said. Reset everyone to compliance-based status. Those in good standing remain beneficiaries. Those in violation remain suspended until they achieve compliance or permanently forfeit their distributions. That would mean, Wesley stopped, clearly calculating. That would mean Florence Harrington is currently the only beneficiary in full compliance with all trust standards, Dr. Price finished, which gives her priority status for distributions during the suspension period. The panic spread quickly after that meeting. Within 24 hours, I received calls from 3 different family members I hadn't heard from in years. Cousins, an uncle, even Vivian herself, all suddenly interested in my well-being and hoping to resolve this unfortunate situation. I didn't take the calls. The family office was scrambling. Staff who'd spent years executing my father's directives were now taking instructions from independent trustees. Distributions that had flowed automatically to my father and Marcus were frozen pending compliance reviews. Investment decisions that my father had made unilaterally now required board approval. He'd lost control of the trust, bound by the same rules he'd ignored for decades. My father showed up at my apartment on a Tuesday evening. I watched through my door camera as he stood in the hallway, looking older and more uncertain than I'd ever seen him. He pressed my buzzer 3 times before finally leaving. He sent a text message. Florence, this has gone far enough. Let's talk like adults and resolve this mess. I replied. Everything is being resolved exactly as the trust agreement specifies. There's nothing to discuss. His response came immediately. You're destroying the family over spite. I typed back. I'm enforcing the standards your father established. If that destroys anything, it's the fiction you've been maintaining. No reply came after that. The independent trustees worked efficiently. Within a month, they'd completed a full structural review of the trust. Their findings were sobering: years of loose oversight, questionable distributions, administrative decisions made without proper documentation. My father had treated the trust like his personal bank account, making distributions to himself and favored family members without regard for the compliance requirements. It had worked because no one had bothered to check, and the administrators he'd hired were more interested in keeping their jobs than enforcing rules. Now those administrators were being replaced. The trustees brought in their own people, professionals who understood fiduciary duty and legal compliance. "We're recommending a permanent governance change," Howard told me during a private call. "The trust needs professional management, not family favoritism." "What does that mean for beneficiaries?" I asked. "It means distributions will be merit-based, tied to actual compliance with trust standards. Your grandfather's original vision, essentially. And my father's suspension. That's more complicated." Howard paused. "The ethical violation is serious. He'd need to make restitution, probably donate a substantial amount to environmental causes, and undergo ethics review. It could take years to restore his beneficiary status. And in the meantime, the trust continues operating under independent oversight. Compliant beneficiaries receive their distributions. Non-compliant beneficiaries receive nothing until they meet the standards. It was everything my grandfather had intended, a trust that rewarded responsibility, not entitlement. The freeze was absolute. Every distribution that had been scheduled for the next quarter was paused pending the compliance review. Marcus's salary from Harrington Industries kept coming, but his trust distributions stopped. Vivian's children lost access to funds they'd been counting on. My father's personal draw from the trust, nearly $2 million annually, vanished. The pressure built quickly. Without trust income, Marcus had to actually work for his money. Vivian's children had to reconsider their expensive lifestyles. My father had to watch as control of his family's wealth slipped through his fingers. I received a letter from him, delivered by courier. It was handwritten, something I'd never seen before. My father always typed or dictated everything. "Florence," it began, "I made a mistake. I let personal feelings cloud my judgment regarding your removal from the trust. I'm asking you to consider undoing the compliance audit and restoring normal operations. The family is suffering, and I take responsibility for my part in creating this situation." It was the closest thing to an apology I'd ever received from him. I wrote back, "The trust isn't suffering. It's finally operating as intended. What you're experiencing isn't suffering, it's accountability." His response came 2 days later, this time typed, "What do you want? Money? Control? Name your terms." I replied, "I want the trust to function according to the standards it was founded on. That's not negotiable." The outcome became clear 6 weeks after I'd initiated the compliance review. My father remained in suspension, unable to achieve compliance without admitting wrongdoing and making substantial restitution. Marcus maintained technical compliance but clearly resented the scrutiny. Vivian's children met the minimum requirements but nothing more, and I remained the only beneficiary in full, documented, legitimate compliance with every trust standard. The independent trustees called a formal meeting to establish new distribution protocols. Given the current compliance status, Howard announced, "We're restructuring the trust's distribution hierarchy. Priority 1, beneficiaries in full compliance. Priority 2, operational expenses and charitable obligations. Priority 3, suspended beneficiaries who are actively working toward compliance." What does that mean in practical terms? Wesley asked. Thomas pulled up a financial projection. It means Florence Harrington receives 70% of distributable income while she remains the sole compliant beneficiary. 20% goes to charitable foundations as specified in the original trust. 10% is held in reserve for operational needs. 70%. More than I'd stood to inherit under my father's original plan. All because I'd actually followed the rules everyone else had ignored. "This is temporary, of course," Dr. Price added. "As soon as other beneficiaries achieve full compliance, the distributions will adjust accordingly." But everyone in that meeting knew the truth. My father's pride wouldn't let him admit wrongdoing quickly. Marcus would do the minimum to stay eligible, and Vivian's children had no real incentive to exceed basic requirements. The aftermath was quieter than I expected. No dramatic confrontations. No family meetings where everyone aired grievances. Just a slow, steady shift in dynamics as everyone adjusted to the new reality. My father stopped calling. We communicated only through attorneys when necessary, formal and distant. The man who'd signed papers to disinherit me for failing to impress was now fighting to regain access to the trust his father had created. Marcus sent an email 3 months after the restructuring. I don't know if you planned all this or just got lucky, but well played. Dad's still furious, but I think you did what needed to be done. It was the closest thing to respect he'd ever shown me. Vivian avoided me entirely, which was fine. Her children maintained their minimum compliance levels and stayed quiet. The trust itself thrived under professional management. Investment returns improved. Charitable contributions increased. The independent trustees published quarterly reports showing exactly how funds were being used, creating transparency that hadn't existed in decades. My distributions came like clockwork, deposited into accounts I'd set up specifically for trust income. I didn't spend lavishly. I invested conservatively, donated generously, and continued working at my law firm because I enjoyed it. The money wasn't the point. It had never been about the money. The new structure was permanent by design. The independent trustees had governance authority unless 75% of compliant beneficiaries voted to change it. Since I was currently the only compliant beneficiary, that meant I effectively controlled the governance structure. My father tried once more to challenge it, filing a lawsuit claiming I'd manipulated the compliance process. His attorneys argued that the audit had been retaliatory and should be invalidated. The judge who heard the case took exactly 4 to 5 minutes to rule. The audit used the trust's own standards and documentation. Ms. Harrington acted within her explicit authority as granted by the trust agreement. The fact that the results were unfavorable to the plaintiff doesn't make the process improper. Case dismissed. After that, my father finally accepted reality. He began the long process of compliance remediation, making restitution for the environmental violations, undergoing ethics review, documenting everything as required. It would take him years to restore his beneficiary status. Years of following rules, of being accountable, of meeting standards instead of dictating them. The charitable redirections were my favorite part of the new structure. 20% of trust income now flowed to foundations focused on education, environmental protection, and legal aid. Causes my grandfather had cared about but my father had largely ignored. Every quarter, I received reports showing exactly where the money went: scholarships for law students, environmental cleanup projects, free legal clinics in underserved communities. The rise wasn't dramatic. No sudden transformation, no triumphant moments where I proved everyone wrong. Just steady recognition of competence and integrity. The independent trustees offered me a permanent role as trust advisor, a paid position that formalized my involvement in governance. You understand this trust better than anyone, Howard said, and you've demonstrated the kind of judgment your grandfather intended for its management. I accepted, not because I needed the role but because it felt right. This was my grandfather's legacy, and I could help ensure it served its intended purpose. My law firm promoted me to senior partner, impressed by my handling of complex estate matters. I specialized in trust law, helping other families avoid the dysfunction that had plagued mine. One client, a woman whose father had threatened to disinherit her for marrying someone he disapproved of, asked me, "How do you stay so calm when dealing with family conflicts?" I read the documents. I replied, "Really read them. Control comes from understanding the details everyone else ignores." 6 months after the restructuring, I received an invitation to my father's birthday party. A formal card, embossed printing, my name in elegant script. No personal note, just the basic information. I didn't attend. We weren't there yet, might never be. But I kept the invitation as a reminder that even my father could learn to follow protocols when he had no other choice. I closed the trust file for the last time on a quiet Tuesday afternoon. Not because my involvement was ending, but because everything was finally in order. Properly documented, professionally managed, operating exactly as my grandfather had envisioned 70 years ago. The lesson had been expensive for everyone involved. My father had learned that authority without accountability eventually collapses. Marcus had learned that compliance couldn't be faked forever. Vivian's children had learned that access to wealth came with responsibilities. And I had learned something too. People who use inheritance as leverage forget one fundamental truth. Control only exists if everyone stays quiet, if everyone accepts the narrative, if no one bothers to actually read the fine print. I didn't fight. I didn't beg. I didn't make scenes or demand respect. I just read. And then I signed. The amendment my father had slid across that table, the one meant to punish me for failing to impress him, had included a single clause he'd never bothered to examine. Discretionary redistribution authority. 3 words buried in legal language, giving me exactly the power I needed to enforce the standards he'd violated. He'd wanted to teach me a lesson about excellence. Instead, he'd learned that true excellence isn't about impressing powerful people. It's about understanding systems, following principles, and having the patience to let accountability work. My grandfather would have been proud, not because I'd outmaneuvered my father, but because I'd honored the trust's foundational purpose, ensuring that family wealth served family values, not individual egos. The pen I'd held in that conference room, the signature I'd written without trembling, those hadn't been acts of submission. They'd been the beginning of restoration. Sometimes the quietest signature creates the loudest change. You just have to know what you're actually signing.